wait maybe a minute or two until we can get started.
Can you see the slide?
I can see black. Oh, there's feedback. Okay, this just means that if we're not talking, we just kill our mics. We just hit the mic thing. Okay, am I muted? Hello, can you hear me now? Okay, perfect. So I'll just give it another maybe minute or two, and then we can get started, just to get everybody a chance to situate themselves. Okay, so I think we'll get our panel started, and I'd like to welcome everyone. Good afternoon and good morning and good evening, depending on where you are in the world. And welcome to panel 16, which is the AfCFTA and the future of economic integration in Africa. And it's really a great pleasure to welcome you to this panel. My name is Kholofelo Kugler, and I'm counsel at the ACWL. So me and my august panelists here would be talking about the AfCFTA, the African Continental Free Trade Agreement, which is the new kid on the block. It is presently the biggest RTA in terms of number of countries involved. So just to let you know that 54 of the 55 AU members have signed on to this agreement and has currently been ratified by 38 African countries. The AfCFTA entered into force on the 30th of May 2019, and trading under it began on the 1st of January 2021, and the delays were largely because of the COVID-19. So what are we talking about here in terms of sort of the coverage of the agreement and the types of countries that are involved? We're talking about a market size of 1.2 billion Africans, and the total GDP of Africa is about 3.4 trillion, and it's estimated, at least at pre-COVID time, to grow to 8 trillion in 2035. Of course, before the pandemic, Africa had 6 of the 10 fastest growing economies in the world. And this agreement is pretty large in scope and in ambition. So not only does it cover the traditional goods and services, but it also covers, of course, IP, competition, investment, and the newer generation issues like e-commerce, women and youth in trade, and MSMEs. The agreement also has an inbuilt development dimension, what we call the variable geometry. There's a recognition in the agreement that not all countries are built the same, not all countries are at the same level of development. And so there's a recognition that also institutional support will be necessary for the successful implementation of this agreement. This agreement comes from actually a very low intra-Africa trade, which is currently sitting between 15 and 18%. So the ambition is to grow these figures. Of course, there are many, many structural and infrastructural challenges, but these are some of the things that we will canvass today. Of course, the virtues of the agreement as well. It's truly my greatest pleasure to welcome these 4 very knowledgeable gentlemen It will be canvassing different aspects of this agreement. So first, I will introduce Mr. Senai Andemariam, who is a former judge and now an assistant professor at the Law School of Asmara in Eritrea. He earned his LLB at the University of Asmara, his LLM from Georgetown University as a Fulbright scholar, and is now a PhD candidate at Maastricht University in the Netherlands. He's a member of the editorial team of the Journal of Eritrean Studies and advisor to the Minister of Justice of Eritrea. He's widely published in numerous reputable international journals. Secondly, it's my great pleasure to also welcome Dr. Henok Asmelash, who is a lecturer at Birmingham Law School in the UK. Prior to joining the University of Birmingham, he was a postdoctoral fellow at New York University School of Law and a research fellow at the Max Planck Institute in Luxembourg for procedural law. He holds a PhD in law and economics from Bocconi University in Italy, which he obtained in 2019. Our next panelist is Dr. Regis Simo, who is a senior researcher at the Mandela Institute School of Law of the University of the Witwatersrand in Johannesburg, South Africa. Before joining WIT, he was a research and teaching fellow at Università Commerciale L. Bocconi, Milan, in Italy, and he's also a former Marie Curie fellow at the University of St. Gallen in Switzerland. He holds a PhD in international law and economics from Bocconi University, a Master of Laws in international trade law from the University of Freiburg in Switzerland, and an MSc in competitive law, economics, and finance from the International University of Turin in Italy, and an LLB from the University of Boué in Cameroon. He's a contributing editor of Afronomics Law blog and a member of the editorial board of the African Journal of International Economic Law and also the International Journal of Public Law and Policy. Finally, our last panelist is Mr. Harrison Mbori, who is a research fellow at the Max Planck Institute Luxembourg for International European and Regulatory Procedural Law in the Department of International Law and Dispute Resolution. He's also a doctoral candidate SJD at Loyola University in Chicago in the United States. He holds an LLM in International Law and Alternative Dispute Resolution, ADR, from Loyola University in Chicago, an LLM in International Economic Law and Public Policy from the Academy of International Economic Law and Policy, and an LLB from the University of Nairobi, Kenya. He's also an advocate of the High Court of Kenya. Prior to starting his fellowship at the Max Planck Institute in Luxembourg, he worked as a lecturer at Strathmore Law School, where he taught courses in ADR, international trade law, and he also coached moot teams. And also this year, his team that he coached from Sri Lanka won the John H. Jackson International Moot Court in WTO law. And his doctoral research focuses on the sub-regional courts and tribunals in Africa on economic, trade, commercial, investment, dispute settlement. So this is truly a very knowledgeable panel that will deal with different aspects of the AfCFTA. And so just to let you know how this panel will work is as follows. We will have each of our speakers intervene for 8 to 10 minutes. And after that, we'll have a discussion in between the speakers. Thereafter, we'll also have a very brief intervention of 2 to 3 minutes. We'll have a short discussion and hopefully leave about 20 minutes for Q&A afterwards. So please feel free to ask questions in the chat box, and we will be very happy to address those questions. Without further ado, I would like to invite Mr. Andemariam, who will talk about the AfCFTA issues, opportunities, and challenge from the institutional and sort of governance issues. So please take it away.
Can you hear me? All right. Thank you for your kind words, Kholo. I feel that you've done the introduction on what the AfCFTA is, what its benefits are, but to make a few more benefits on top of the list that you've just mentioned. From the point of view of inclusivity of the package of the AfCFTA, I see that in phase 2, African countries have promised to include investment, intellectual property, and competition into the package, which therefore can be considered as an opportunity to include investment and competition into a big package. And this can be a model for, say, the SIEL is working on investment and competition issues, include as a benefit or opportunity the fact that the leadership, the African Union, the Assembly of Heads of State and Government, is doubling as the Assembly of the African Continental Free Trade Area. This gives us an added advantage of political support that the AfCFTA might want, that we don't have a separate assembly. The AfCFTA can be considered as a tool that can be seized. If you look at the agreement that established the African Continental Free Trade Area, there are a number of things that refer to WTO law, WTO acquis, processes, models, and jurisprudence. Therefore, as the AfCFTA kicks into reality, can make a contribution. It's just a track. Of course, the AfCFTA will benefit from WTO law, process models. It can also contribute to develop trade law in Africa, and these dispute settlement process. They might contribute to development of international trade law, and through that, of course, contribute to international law. I'll come back to this later. Point number 11 refers to the dispute settlement process of this new African regime, and the it creates to bypass such difficulties as choice of forum, choice of law, recognition, and enforcement of awards, which have been some of the bottlenecks to solving African trade problems. Therefore, these can be as some of the benefits or that can be seized as this new trade regime in the continent kickstart. There are, I think, should we think about the, for instance, that some writers consider the Continental Free Trade Area as and it might be less pragmatic, given the other areas that need to feed into the trade regime in Africa. Also, the perennial issue in regional economic communities, recognize regional economic communities in Africa, can not only development of the AfCFTA, but also the link that they might have given the multiple membership issue in the African continent. A side issue in relation to communities might be that free trade area can be considered as an Article 24 free progressively customs scheme, but it also has regional free trade areas and regional economic communities. We think of an FTAs within an FTA. Folks needs to also be considered. These trade plus issues, human rights, climate change, intelligence, and launch a digital platform. And how that works will be an issue as we move forward. Factors, and of course, the peace factor in the country will either way the objectives of the African Continental Free Trade Area. Let me quickly move. Challenge. I see that there will be although the regime, a new trade regime in the world, but there will be some challenges like any other free trade. I've divided the challenge into groups. There are these general institutional issues, dispute settlement, and economic. So what are challenge, challenge of African economy, not only the free trade area, but also the African Union itself, whether this is a colonial, the French issue, colonial or neo-colonial dependency on Western economies and institutions. Therefore, of dependent foreign factors with a challenge to the speed that we catch up with continue to be another challenge. The elephant in the continent, not in the room, is the issue.
Hello, Senai, you disconnected for a few seconds. Can you just go back the issue of China? I think that's where we lost you at the issue of China.
For the South, as an example, continued national sentiment, border issues, all the colonialism.
Hello, Senai, we are losing you. Hello, can you hear me? Yes, we've lost you. Unfortunately, the connection is not stable. So, we've lost quite a bit. I think from about China, we lost some of the things. So if you can repeat, maybe try speaking, and then we'll see how much. Yes, now we can hear you. Yes. Would it help? Oh, okay. So we've lost him completely. Okay. So what we're going to do so that we don't waste any time is that we're going to continue with our next speaker, which is Henok, who will talk about, the external relations of Africa and, third-party states. And once Senai can log back on, we'll just ask him to conclude because he just had a few minutes left. So if you don't mind, Henok, just stepping in, and then we'll deal with the tech issues as they come along, as they get better.
Great. Thank you so much, Kholo. Thank you, everyone. My presentation is based on a paper on the extents of the African Continental Free Trade Area. I refer to it as the CFTA. And in this paper, I read the question whether the CFTA needs a common external trade policy. And this question is prompted by recent developments in the extra-regional trade relations of CFTA member states. As Senai started saying, the establishment of the CFTA created a lot of excitement across the continent, mainly because of its potential to enhance the currently low level of intra-African trade, but it also because it built an expectation that it will enable African countries to speak in one voice in international forum and to enhance their bargaining power. But despite the establishment of the CFTA, CFTA members have continued to negotiate and sign trade agreement with third countries on their own. Since the adoption of the CFTA agreement in 2018 in Kigali, Mauritius has become the first African country to sign an FTA with China. Kenya has also launched a negotiation with the United States for a bilateral FTA. A number of African countries have also signed trade agreement with the UK after Brexit. These unilateral actions, and particularly that of Kenya, has attracted a widespread attention and criticism from the other CFTA members, but outside the CFTA as well. And the AU Assembly, which is the highest decision-making body of the AU, as well as the CFTA itself, has taken two decisions since. The first one in 2018, where it enjoined CFTA members from signing trade agreement with certain countries until the entry into force of the CFTA. And last year, where it's mandated the CFTA Secretariat to sort of follow up developments concerning trade agreement with certain countries, also to develop report lines, notification templates, also include a section on third-party agreement in the future collaboration framework between Pan-African institutions. So all these reactions and criticisms are really interesting when you take into account the fact that the CFTA, as Senai said earlier, is basically an FTA, right? And the conventional typology of economic integration schemes tells us that one of the key characteristics of FTA allow their parties to retain full sovereignty over trade policy vis-a-vis third countries, unlike customs unions and other deeper forms of economic. So it is interesting where this criticism is coming from, why the unilateral actions of CFTA members attracted this much attention, and what makes the CFTA or African FTAs in general unique in that sense. So the first point to ask is whether these actions are lawful under CFTA law, right? Under CFTA, there are few provisions dealing with third-party agreements. Article 18 of the CFTA agreement itself and Article 4 of the CFTA protocol on trading goods and trading services. These are MFN clauses. In total, these provisions basically provide that CFTA member state can negotiate and sign trade agreements to the extent that these agreements do not undermine the objectives of the CFTA and its protocols, as well as the preferences given to third parties are extended to CFTA members on a reciprocal basis. I think we can argue over whether this agreement, this unilateral agreement, undermine the objectives of the CFTA, but in general, I think it's fair to say that this unilateral agreement with third countries are lawful under the CFTA, right? So if they are lawful, and the conventional typology also tells us that FTAs has nothing to do with the external trade relations of its parties. So where is this criticism coming from? I think to understand this, we need to look beyond the CFTA law and beyond the conventional typology, right? As Professor James Gatti told us a long time ago that African FTAs are flexible legal regimes with multiple objectives. We have to look at the African FTAs on the putting them in the context of their historical development. So we can find several explanations of where what is the factor that are driving this criticism and the reactions of the AU. Both economic and non-economic concerns are there. The first one is, I think, concerns about preference erosion, right? The CFTA promised to enhance intra-African trade by providing preferential market access for African goods and services market. But if African countries continue to sign this agreement, that value of the preference, the privilege, is going to decline, right? So there is an obvious economic concern. But this is not unique to African FTAs, right? This is the same with other FTAs as well. The other factor is the fact that these agreements have this standard setting implications. If you look at China FTA, and if you look at the Kenya-US trade negotiations, both the US and China has made it clear that their intention is as a model agreement that they want to replicate with other African countries. So one way or another, of course, what Kenya agrees or Mauritius agrees is not binding on other African countries. Other African countries can reject it. But given the power asymmetries, you know that these agreements are going to be the starting point of negotiations, right? So it is important for the other African countries to make sure or to react to this agreement. But beyond this, in my opinion, the most important that is driving all this reaction is the fact that this agreement flies of the ideological foundations of the African economic integration process and the CFTA itself. As you know, the African integration process was born out of the struggle for liberation. So in its orientation, it is a defensive mechanism to overcome the marginalization of the continent in international economic affairs. So if you look at the legal instruments of economic integration, going back to the 1970s and all the way to the CFTA, the few general concepts that appear consistently are concept of Pan-Africanism, continental solidarity, collective self-reliance, speaking in one voice. These are the principles that guide the integration process and the CFTA itself. So now Kenya and others going alone and negotiating third-party agreements on their own contradict that notion. Solidarity, and you find these notions not in terms of binding obligations, but as general principle guiding the CFTA process itself. So if you look at the CFTA preamble, it refers to the Abuja Treaty for the establishment of the African Economic Community. You see also cooperation in trade policy matters and also ensuring coherence in the trade relations of members with other countries in the preamble as well. So all these notions are there. So that's why now we see these reactions. So in general, when you look at the actions of individual CFTA members, Mauritius and the CFTA law on one hand, and the reactions of the collective reactions of the AU Assembly on the other hand, you see discrepancy, right? There is a gap between the rhetoric and the reality. The reality is that countries have their own national economic interests that's driving them to sign this agreement. On the other hand, there is this continental solidarity that's guiding the integration process, serving as a guiding principle. So that contradiction exists, and how could we resolve that contradiction? That's the most important question in my opinion. And how to go about it, I don't know whether I have time. If I have time, I can continue, but otherwise I can come back to it. Do I have?
Henok, I'm going to let you keep this because this is a very interesting part. If you don't mind, we'd like to park it for the next round, because I'd really like to sort of get into that. So thank you very much. Very, very interesting interventions, which we'll discuss in a little bit when we have our internal chat. But I'd like to turn over then to Regis for his discussion on freedom of movement.
Thank you, Kholo. I was thinking Senai will join us, but she's no longer here. She's not here yet. Well, thanks. My own presentation deals with the freedom establishment, which is part of a trade agenda and also part of the free movement of people protocol. Well, basically, the paper actually centers around the free movement, the protocol to the African economic communities relating to the free movement of person and right of establishment that was presented to the African Union member states at the same time with the AfCFTA. So why the AfCFTA agreement actually there has been a lot of enthusiasm around the AfCFTA agreement. The protocol itself to the African economic communities has not attracted that much attention, or at least not the same level of attention between African Union member states. So up to now, up to today, we only have 4 countries actually ratified that protocol. And so the question that I actually try to instigate is whether and to what extent that exercise to disconnect that free movement of people from the trade agenda can actually work in reality, bearing in mind the fact that free movement of people and right of establishment are relevant, at least for the trade in services and also in investment, which is part of the phase 2 of the negotiations of the AfCFTA. So you have the protocol that actually defines or provides for the right of establishment as to be achieved at least in the 3rd phase of the African Economic Community in that protocol. So this is still the old spirit that you find in the Abuja Treaty, whereby the African Economic Community were to be established in phases, phase 1, phase 2, and the 6th phase were to be devoted to the liberalization of services and free movement of people. This is still the old thinking, because even in the African Economic Community protocol that was signed in 2018, you still have the under Article 5, the fact that the freedom of establishment or right of establishment is to be achieved or to be realized in the third phase. So first movement of entry, relaxation of barriers to entry, and then it's only on the third phase that we have, the establishment. Yet, at the same time, you have in the Protocol on Trade and Services the provisions that actually guarantees that the liberalization of mode 3, which is commonly called mode 3, which is freedom mode 3, whereby a citizen or a national of one state party to the protocol actually establishes himself in the territory of another state party, and then conduct or at least provide services on that particular basis, or doing so on the particular either temporarily under mode 4. But yet you need to, in order to realize mode 4, for instance, to have a relaxation, or at least of some barriers to the free movement of people, which is to be guaranteed under the Protocol on the Free Movement of People. So these two instruments are interlinked in that particular, at least related in that particular perspective. Yet, when you come to the dispute settlement understanding of, or the dispute settlement mechanism on these two instruments, both are interstate dispute settlement. In the AfCFTA, only states can actually have standing to actually complain when there is, or at least around the interpretation or implementation of the protocol, either the AfCFTA agreement or related protocols. The same applies with the protocol on the free movement of people to the African economic communities. Even there, the dispute settlement mechanism actually provides that only states can actually dispute. For when individuals have outstanding, is only to when they have some barrier that they can actually vindicate as a human rights issue. Then they have to go to local courts and then vindicate that right, or to the African Commission. Then that's where the right is conceived as a human right. Now, I believe that this is a confusion, or at least there's something that can happen because if the African Court of Human and People's Rights, which is the forum for dispute settlement under the Protocol of the Free Movement of People, is to be, when it's going to be established, that court is potentially competent to hear trade matters. Why? Because if an individual feels that, or at least if a state party believes that the right of its citizens is being impaired, at least there is barriers for the realization of freedom of establishment, that right can fall under the barriers to freedom of establishment or the protocol or training services, and it can fall at the same time under the barriers to the realization of the right of establishment. So, which gives the impression that since it is an interstate dispute settlement mechanism, we are now back, for instance, to the area of diplomatic protection, whereby since individuals do not have the right to bring claim, it is going to be on the particular. It will fall on their state, on their home state, to actually be able to vindicate those rights, which is something which is a development which we are actually seeing under this AfCFTA or International Economic Law instrument. So now, I try to believe that, or I try to argue that, even though we are still in the agreement is still in its infancy and hasn't been tested yet, there is room, at least because individuals are the ones that actually face barriers. Companies are the ones that trade, and if states are not willing, or as we have seen, we have practice of states that the interstate African countries do not actually litigate amongst themselves. And if that doesn't happen, what will happen to the protection of these individuals or companies that actually want to establish in those markets and then face barriers? So I believe that even though the agreement has not been tested, it's still new, has not been tested yet, there is room for reform in that regard by actually providing for access or at least for companies and individuals into those markets, because as you all are aware, regional trade agreements in Africa, some of them actually provide for in the treaties that residents can actually petition the court when their rights to establishment is being tampered with. For instance, the COMISA Treaty, for instance, actually guarantees that companies can actually sue a member state when they don't respect their obligations, or when the implementation is it's not being respected. So for me, I think this is where some of the issues with the beginning of the AfCFTA, which is still in its infancy, as I mentioned, can actually been tackled. So this is briefly the comments, or at least my introductory remarks.
Thank you very much, Reggie, and for also sticking to the time. I mean, you've raised quite a number of, challenges, which we'd like to also talk in a few minutes when we have our discussion. But just to change a little bit of tack from trade to investment, we'd like to invite Harrison to talk about investment dispute settlement within the context of the AfCFTA.
Thank you so much, Kolo. I hope you can hear me. Thank you. It's an honor and a privilege to appear in this panel with people who have inspired me and I greatly admire. So it is indeed good to be here today. And my topic specifically concerns dispute settlement, and it might piggyback well on some of the things Regis was talking about. As has already been mentioned by the previous panelists, we will move to phase 2 with investment and competition. So investment, at least in the FTA, has not yet been decided yet. One thing that has been mentioned is that those negotiations are going to be founded, at least for investment, on the Pan-African Investment Code. So that we know. Now, in this sort of work and paper that I'm trying to develop, I'm trying to say that maybe we should think about the field that we're talking about in 3 broad categories. There can be more when it comes to ISDS specifically. The first one is what I would say is, and this is all the stakeholders involved, some sort of wholesale acceptionism that many people still accept it's there, it's okay, and it should continue. This is rare to find, I have to say. I mean, you will have found it before, but now it's very difficult in all discourses on ISDS to find a complete wholesale acceptionism. Everyone is saying there needs to be some kind of reform. Whether it's substantive or procedural, there's some kind of reform that is needed in the system. Even the people who love it the most have accepted this. In the middle, there are people whom I say, or stakeholders whom I might say are mild acceptionists. They are reformist also. So everyone from now on is a reformist. And here you find scholars and states and agreements that say, let's change the venue. Let's move from arbitration and take this to court. Maybe this is the EU sort of direction. Let's come up with a multilateral system or court. And some people within mild acceptionists also say, okay, let's move to a court, but the court as an institution. In my view, this is where PIKE is. PIKE says that it's an Africanization. This is a Pan-African Investment Code. But if you look at Article 41 of PIKE, when it comes to ISDS, it's sort of is not saying we are going to, first of all, it accepts that ISDS is going to continue. Second of all, it grants the states the rights to maintain it based on their domestic laws and legislation. And thirdly, it grants them a number of options, including the possibility of going to court, the possibility of going to regional courts. Now, let me talk about these rec courts, because this is partly what I'm doing for my PhD. In my assessment, all of them can accept arbitration cases, including investment arbitration cases, not just ECOWAS. I mean, there's this discussion out there that ECOWAS is the prototype. All of them, the ESCJ, SADC, as was previously constituted. After 2014, things have become tricky with SADC. But OHADA is like, for me, if people were talking about a prototype, I wonder why not OHADA, because to me, OHADA is the best prototype here. But the fact is that including COMESA, all of them can accept this, but not as courts, but as arbitration institutions. Not as courts at all, it's just as arbitration institutions. This means that it's not the judges in these regional economic courts that sit over these cases, it's actually they're standing as an institution. And Pike also has this agenda of saying, let's go to African institutions. For me, this is very mild Africanization. It's, if you are going to have these cases, so for Pike, for example, when it says state to state, it says go to African institutions. And this means the African arbitral institution. So this is like there's one in Kigali now, the Center of Arbitration. There's one in Nairobi. The Cairo one has been doing quite well. So the courts can work in the same way. The problem that I see here is competition for getting these cases. And these ad hoc institutions can do it much, much better than the courts themselves. Then the other thing with mild exceptionism is the introduction of exhaustion of local remedies. This you will find in the SADC protocol. It insists that you must exhaust local remedies before you go either into arbitration or to the SADC tribunal. The problem with this is that the SADC tribunal seems to have moved from allowing individuals to sue. Now it's state v state. So you wonder how will the investors, even if they exhaust local remedies, go to the SADC tribunal that has now closed the door for them? And this is me just saying, there's a lot going on out there. Then the last part of this, which is the last sort of chimney of discussion, is what I would say rejectionism. And here, let me start with complete rejectionism. But first of all, a caveat. I don't think there are any rejectionists who are saying investor state cases or disputes should not be heard. I've not heard anyone who's saying, this dispute should not be heard. I've heard in some discourses people saying, oh, these rejectionists are crazy. Disputes will come up and disputes will be heard. I have not heard that extreme view that, don't hear these cases. The rejectionists, first of all, are saying, hear the cases, but not in international arbitration. This is the extreme agenda of rejectionism. And I've not seen any example of this in Africa. Outside there is already happening. The Australia-UK FTA is a good example of just no ISDS. I think the USMCA also, it's a bit complex in its iteration, but it has a part of it, especially for Canada, that says no international arbitration. Then there are rejectionists who say, if there is no arbitration, then maybe the domestic courts should be the venue. The best example here for Africa is South Africa. And I think they have insisted on this, though when you get to SADC, like I've already stated, things get very complicated. Now there are the rejectionists who says, let's go to regional courts. And like I've said, the regional courts, you might go to them as arbitral institutions, or you might go to them as, in a quote unquote multilateral court, so that then it is the judges themselves that are hearing these cases. The outlier states that I can give as example of rejectionists are South Africa is a good example, and Tanzania, but Magufuli Tanzania, not Suluhu Tanzania. We need to be careful now because Tanzania seems to have completely changed with the new president, and maybe things will change so completely that we will not have the Magufuli, because they had already come in 2017 with legislation that were pretty rejectionists. Now, those for me are the three sort of chimneys that are there. Now, as we discuss the AfCFTA, where will we go? With all of this on the table, for me, there's a lot of discussion that needs to be done, and maybe some very careful calibration. And that's what is being presented. Thank you.
Thank you. Thank you very much, Harrison. Unfortunately, it seems like we have lost Senai for now, and I hope he can come back. But in the meantime, with your indulgence, I will present some questions to our panelists. And of course, you can intervene also, panelists, to speak. Now, let's start with you, Henok. I mean, thank you very much for your chat. And I think it's very important, especially you raised this issue of continental solidarity, which I think to many, when we see the AfCFTA coming up, it's a foregone conclusion. It's almost like all African countries are in. I mean, we see Eritrea, which is sort of the outlier, who's still kind of holding back on this issue. But, we've got 54 states that are pretty committed to this project. And so I think I want to jump into what you were going to say. We have this continental solidarity, but we also have independent state economic and developmental aspirations. So how do we balance that on the background of knowing that the AfCFTA allows state parties to conclude external agreements, and also in the regional setups themselves also allow such? So, for example, in the EAC, in the COMESA, for example, Kenya is completely allowed to do what it's done. And so how do we then find a solution, as we know, and as you said to us, that the AfCFTA is an FTA and not a customs union. And we cannot wait until, we've concluded the customs union phase. So please, can you just, jump into what you're going to jump into right now?
Great. Thank you, Kolo. That's a very important question. I think the standard kind of policy prescription in this case will be, establish a customs union. But establishing a customs union, Kenya has shown, as you said, within the context of the East African community, which is a customs union, but Kenya still managed on its own. So establishing a customs union itself is not a solution to fill this gap, first. Second, I think if we wait, for example, if you look at the CFTA legal instrument, there is a clear indication that the CFTA is going to be a stepping stone to the establishment of a continental customs union. And if you refer to the 1991 Abuja Treaty, the Abuja Treaty envisages it takes 2 years from a free trade area to customs union, but I don't think this is practical, right? It's going to take a lot of time to convert. I mean, there is a lot of talk about how fast the CFTA negotiation has been, but the process started way back, right? In 2012, I remember I was an intern at the African Union, and at the time, people were thinking this is going to come sooner, so it still took 8 years to arrive. So the customs union will take time. The problem is, if it takes time, and by the time, if you consider a customs union as a solution to this, by the time we, the continent have a customs union, most member states would be signing these agreements already. The signing of this agreement itself undermined the establishment of customs union, because the more different trade agreement you have with extra regional trade partners, it comes to set, for example, a common external tariff and all those things. So I think we have to think beyond the customs union context, right, in terms of forming a continental common external trade policy within the framework, within the legal and institutional infrastructure that exists within the CFTA. I think we can work around soft law basis instead of jumping on, establishing a customs union. First, and the most important thing is, I think, to enhance the coordination. I think the AU Assembly has taken an important step in this direction, mandating the Secretariat to provide, to develop a notification template. So notification is important, but in my opinion, more mandate need to be given to the Secretariat, for example, to participate in this negotiation as an observer and communicate information with African countries. But beyond that, and I think the major step that the continent can take in this direction is following what Harrison was talking about, the pike. For trade, at least identify certain areas which are of common interest to the continent, where you need a common solution, for example, intellectual property and other areas. So you can identify certain areas of common interest, and on those basis, at least you can set minimum standards. Individual countries can still go on and negotiate a better deal, or but still having some sort of minimum standard for certain areas would help in bringing countries together and having at least the continent still speak in one voice, but in a different way.
Sorry, so I just have a very, very quick follow-up question, and then I would like to take advantage of the fact that Senai is back. So you made us known to us that at least Article 8 of the AfCFTA agreement talks about the option to provide all the preferences on an MFN basis. So this kind of poses an argument against preference erosion, no? So if individual countries conclude agreements and they give MFN treatment to African countries, then there would not be that preference erosion. So what do you think about that?
So what I refer.
Hello?
Can you hear me?
Yes, now we can hear you.
I think there is a background somewhere. Yeah. So what I refer to as a preference erosion is, of course, whenever an African country signs a trade agreement with a third country, the preference erosion comes in the form of that. Of course, the MFN clause required that the same treatment should be extended to the CFTA members as well. But in general, when you think of the CFTA and all this excitement, the fact that the CFTA, by reducing barriers to trade, provides that extra privilege for African products and services. So when these free trade agreements are concluded with regional partners, that privilege is eliminated, right? So they will have the same treatment, right? For example, in Mauritius, African products and Chinese products will have the same treatment. There is no privilege that is left for African countries. That's what I mean.
Thank you very much. Loud and clear. Senai, I would like to take advantage that you're back and just ask you a question on your very interesting intervention. And we heard some of the challenges that you sort of posed to us. But what I would like to focus a little bit on is this concept of FTAs, or FTAs in an FTA, or FTA around FTAs, and just get your opinion as to how do you envisage the AfCFTA collaborating, coordinating with the very different, REC regimes in Africa, and what is the real value, to the African continent, based on what we have, these 8 regional economic communities or blocks that are pretty established, and some of them have gone really far, especially in East Africa. So, what is really the added advantage of having this regional or intercontinental agreement?
Well, I've looked at this issue from the angle of Article 24 of the GATT. Can you hear me? All right. So all roads lead to Article 24 of the GATT because most African countries are members of the GATT, hence obligations to notify the WTO in case they join any FTA, whether it's regional or continental in our case. Now, this can be an advantage because the literature on Article 24 seems to accept and encourage members to join as many FTAs as possible, because the eventual goal will be to reduce all barriers as much as possible. On the other hand, however, there is this issue of multiple membership and different levels of success, as you just mentioned. And also the agreement on the AfCFTA seems to recognize this problem, that it doesn't want to do away with these regional economic communities and considers them as building blocks for realizing the dream of AfCFTA. Now, the solution I recommend is that the problems with this multiple membership and different levels of success do not necessarily have to do with the structure of the FTA agreement, respective FTA agreements, but the different political and economic situations in each corner of the continent. Take IGAD, for example, have done some publications on this issue. The problem has been not the vision with IGAD, but the historic tension between some members of AMITEC, Eritrea, and Ethiopia, for example. Therefore, if you externalize the problem with these FTAs, I believe that the issue of an FTA within an FTA, it might even be a customs union that the African continental free trade area will be with. For example, some of these regional economic have reached the level of a customs union. The East African community, for example, then in that case, it would be a customs union within an FTA within the WTO. So this issue of multiple membership or problems can be solved if most of these external issues can be solved. And that's why I state that the fact that the highest decision-making organ of this new African Continental Free Trade Area being the Assembly of Heads of State and Government of the African Union can be a plus or a minus, if I have answered your question somehow.
I would like to jump into specifically what are some of the proposals, what are some of the solutions that you propose can solve the spaghetti ball that we have here? Sorry, Senai, you're still muted.
Yes, I can hear you. How about now?
We can hear you now.
Yes.
Yes, we can hear you loud and clear.
Well, I raised I would be happy to answer this question with a question than an answer, because I raised this question in the discussion yesterday on unilateralism, plurilateralism, and multilateralism. I think maybe maybe we're not ready to accept that this is the new reality in the world, where countries have to work on a triple level of engagement: unilateral, regional, plurilateral, and multilateral. So I think it has to do with designing a way of how to live with this reality than to solve or even do away with the issue of multiple membership. I was going through a table of membership of African countries, and I think we can see some benefits. And the new arrangement that the AfCFTA can become a platform to, say, settle the difference in levels of success among the 8 recognized regional economic communities. I think that is, for me, the new reality that we have to live with. So I do not have lots of solutions, because I think the problems seem to continue. I think the stronghold is on our thinking and expectation that these things have to be solved, than thinking or looking at them from the point of view of seizing the opportunity.
Yeah. No, I mean, I really take your point. And I think
that's a wise way of saying that. I don't have a lot of answers to this.
No, I completely take your point. And I think we're very much conditioned to seeing the model being the EU. And for us to think that various very different models can live in sort of in harmony together is still very difficult, And so maybe that's that. Maybe we should just condition ourselves to saying that this is not the model that we're used to, and we should somehow work within the model. But obviously with trying to fix some of the problems that exist, the obvious problems that we might face, and we face already as a continent on a sort of integration level. Okay. Thank you very much. And we're very happy to have you back, Senai. And Uchenna Ugu actually very much appreciates your comments that you made about the pragmatic solutions. Luigi, I would like to go back to I guess, services, free movement of persons and that. And I mean, this raises a lot of, I think, also emotional, I guess, issues, especially within the African continent. And I think Simo, I think it was maybe Senai who raised this anti-Africa sort of sentiment. And so, my understanding of how, trade and services works is all about schedules, right? So you've got certain commitments that certain countries have made, and you've obviously made some, interventions on mode 3 and mode 4. And that seems to be sort of very country specific. And so I'd like you please to just walk us through, what are the general sort of commitments that should be made, that are being made, and is it really realistic, and will it happen in our lifetimes to see a complete, freedom of movement that we see? And I'm sorry to invoke the EU as an example, but, the African integration process was very much, focused and looking at the EU as a model. So how, do you propose, or how do you think that it will work in the African context, given, the challenges that we've been seeing recently, from South Africa and other countries in terms of intra-Africa migration?
Yes, Kolo, that's really a political and very difficult question to actually tackle. But yeah, I tend to discuss that in a way I think, well, basically, as you know, have to schedule commitments based on a sector that they want to liberalize and mode of supply that they want to liberalize. So you can liberalize the sector and a particular mode of supply, and you can even in the particular mode of supply, particular sector, not liberalize a certain mode of supply of that particular subsector. So this is what is being negotiated at the moment at the AfCFTA, which is not yet concluded. Well, negotiation was supposed to be concluded June 2021 in services, but I'm not sure it's been the case. I've not followed that for it's been a week now. Things it was supposed to be concluded. Basically, even the fact that the member states, the EU member states, actually detached movement of people from trade actually speaks to what they consider to be something very much more political than being related to trade. Well, you see, even in the Mabuya Treaty, like I was mentioning, member states actually thought that the liberalization of movement of people, or the realization of the right to of establishment was to be established, was to be realized at the fifth or the sixth stage of integration. So basically, they still believe that some factors, such as movement of people, needs to be tackled in more carefully than moving goods across the border. And I totally understand that. Even in the WTO, the liberalization of Mode 4 is very complicated. It raises a lot of political considerations among WTO member states. So whether we will see the realization of that right in our lifetime is very difficult to answer, because we also have we are all aware of the that sentiment that you feel in Africa, that states are very reluctant to open their borders. You see that even the African passport, so to realize that instrument, that would be very challenging to actually, because you see that African countries actually find it difficult to move from one country to another, even in Africa, based on the restrictions that are in place. So for that to be realized, there needs to be a really political will, which is still at the moment still lacking among African Union member states. And the AfCFTA, like I said, when it comes to the provision of services, would depend much on the relaxation of these sort of barriers for the realization of trade, at least in those modes of supply that rely on the people, on factor of people moving from one border to another, to be able to trade in the particular sector or particular mode of supply of that or of particular services. So this is what I believe needs to be tackled by EU member states. There needs to be a strong political will among member states to realize that those rights, because also the future of the AFC, of the continent, integrated continent that rely on the people, that is centered on people, that I mentioned in a lot of AU instruments, needs to be tackled along that with that kind of philosophy in mind, because of course the continent depends. Trade will not move if people are unable to move. Even if you find the thing is that you will find that even the movement of goods sometimes is very hindered by that same sentiment that protectionism is very strongly embedded in African states, so that free movement of people is not just, it's maybe a consequence of that thinking among state bodies.
No, I mean, I absolutely agree with you. I think the mindset has to completely change, and it has to change. And I think maybe COMESA can, show us an example, at least get companies being able to access the courts. Because if you see the movement of people as just a human right and not a trade issue, I think it's difficult to kind of, balance the two. On the one hand, I want to establish my company in your borders, but I cannot personally move there. But and I'm going to move into Harrison. We're trying to increase intra-Africa investment under Mode 3. So I mean, I think it's definitely an area that's very sensitive, but definitely an area that I think needs to be really high on the African agenda if we're really going to see the realization of this project. And Harrison, I would like to sort of smoothly move into your investment intervention, which is really, really interesting. And I think this is not only sort of an African issue, but it's a topic that's been discussed, all over the world. We see, some South American countries having left exit, coming back to exit, some, the EU and Canada and Australia and such sort of going away from this investor state model. And then, as you mentioned, we see, countries like South Africa that is sort of, rejecting it and opting for domestic court. So now we know, as we have in of course the trade part, in investment, we have very many different regimes. So we have regimes like in South Africa, and then we have the SADC court, which is not working right now. And then we have, other regions that are a little bit more flexible. And then on top of that, we have PIAC. And so how do you think that the AfCFTA investment protocol should look, and what should be aspiration for Africans, especially, of course, looking at foreign direct investment externally, but also intra-Africa investment as well, and particularly as to what type of dispute settlement mechanism should we be looking at? This is very pertinent because the negotiations are happening right now, so maybe some people are listening in there that can borrow some tips from you.
Wow, I think, yeah, that's a difficult question, Kolo, but I think one way of answering is, first of all, to say that, things are related. Like you said, services are related to investment, at least in terms of mode 3. There's need for countries to deal with the protectionism issues that Regis was mentioning. Interestingly, I know that Ethiopia, which has been very protectionistic when it comes to telecommunications, just recently put out a bid, which a Kenyan company, Safaricom, won. So I was looking at this and I was saying, okay, this is good model at farm level. This is how intra-African investments can occur. Interestingly, for services like, say, telecommunication services, because it's a very good infrastructure of telecommunication services in Kenya with Safaricom and the M-Pesa service, which is like really, really big. If that can extend like right into the region, and I don't know how far it can go outside of East Africa, that's a good way of seeing how intra-African investments can grow. But there are challenges. Now, moving on to the question of investment, I think also BC had asked this, so where do I foresee this? I really am very, very sympathetic to the rejectionism view, but I also understand the realities of already what we have and also the pragmatism that we have been talking about. Now, we maybe must copy or should think about copying the US MCA, that the new NAFTA. Maybe calling it like that is easier. This new acronym is so strange for me. I mean, it used to be easy. You just say NAFTA. Nowadays, you have to, So because they have this interesting idea that not everyone has to be in for everything in dispute settlement. Maybe if we want to agree on a good dispute resolution protocol, we have to allow people to say, guys, come up with a system that will allow myself, South Africa, to say, I'm not very happy with ISDS, so I'm out, but state to state, I can come in. In fact, the new NAFTA is very interesting because, and Regis will be interested in this, because they even carve out services. Not just services, they carve out a few sectors, I think infrastructure, telecommunications. And if you want to opt in into that, for dispute settlement, you can opt in into that and say, I'm opting in only on ISDS for telecommunication services, and I'm good. You guys can deal with the rest. I'm not in for the rest, but and to allow other countries to join in when they want. So it has to be a very flexible system. And here, of course, I'm borrowing from my supervisor, James Kadi, that our system is super flexible. The African, and we must continue with this idea of flexibility, because I don't see people going for a singular system that says, the way Pike comes, it has flexibilities, but I'm not sure South Africa will be happy, or Zimbabwe will be happy with how it's going to work. And therefore, what I foresee is a continuum that allows different countries to opt in where they want to opt in, and say, this one I'm not willing to opt in. And a possibility of opening that possibility and saying, maybe in 10 years, maybe in 20 years, you'll be ready. Then you can jump in. How that looks is going to be tricky to come to, to draft that is going to be very tricky. Because, and this is my comment on Henok's presentation, because of the problem with the MFN clause. I have criticized it before. And when I criticized, I was told by some very senior African scholars that, life is so complicated, and maybe we will not have agreed on this if we did not have that kind of a clause. And when I went back to think about this unconditional thing, it's as if the North African countries will not have signed on the dotted line if there was not an unconditional MFN provision. And maybe that's the flexibility that is in there that allows country to go to third party. And Kolo, just finally, because this is an interesting view also for Henok's presentation, Kenya, has signed the EPA with the UK specifically, and this was a piggyback on what had been negotiated with the EU and was ready. And then Tanzania, of course, Magufuli's Tanzania said, we will not sign it. And now everyone was in trouble because in the EAC, there's this requirement that, you need to go in together or you go out together. Now the UK gave a good opportunity for Kenya to say, all of you are going to enjoy the LDC provisions of the everything but arms. I am not an LDC like all of you, so I'm in trouble. And in that sense, I really understood where Kenya was coming from. And I don't know, Henok might be interested in this because, the discussion at the EAC and at the sub-regional levels for signing of third-party agreements is interesting to see and influence the discussion at the AfCFTA. So that while it's legal at the AfCFTA, for me, it's illegal. It's just in the EAC, it's not. I mean, I don't see a way of saying that it's acceptable if we are a common market or a customs union. It's just, what we have learned. And the treaty says it. So the treaty says it, and we just decided to say, life is so complicated. You guys are going to hold out for a long time. We're not going to go together with you. So we are going in now. Maybe you might come in later. Prof. Gadhi and I have criticized even our going in because the deal is so bad substantively. But that Kenya was in a dilemma, I personally completely understand that kind of dilemma. Yeah, thanks.
Thank you so much, Harrison, and also for your comments. And I really appreciate this a la carte, sort of proposal that is on the table, not only for investment, but for other sort of disciplines as well. And so what I'm going to do, and I'm sorry, as moderator, I'm going to take this liberty to go into the questions because we really have a lot. And I know we promised a second round, but I'm sure you panelists would understand that we would like to also address some of these questions that our audience have posed. And so I'll start with the Chaina's first question. And he says, I think it goes to maybe your presentation, Henok, about signing bilateral deals. And he talks about the RTAs, the EPAs with the EU and other bilaterals. And he says that these conditions that have been signed are WTO or TRIPS plus, but they also exist in the AfCFTA provisions. So how do we then expect that the AfCFTA will work with, I guess, these sort of more liberalized or, expansive, commitments that have been taken on?
I think one thing which is really important to is the CFTA came at the time where there is a significant shift in the trade regime governing Africa's relationship with the rest of the world. Then, as most African countries traded internationally on preferential basis, right? When you look at least with their major trading partners, with the EU, there are GSPs and the EBA scheme. With the US, AGOA and GSP, India has duty-free, quota-free access for African countries. So most of the trade whereby African countries have preferential access. We can talk about whether those preferential access were useful in terms of practice, but in general, African countries didn't really engage that much of reciprocal trade negotiations. But now this has significantly changed over the last few years. It started with the EU post-Continental agreement, replacing them with a reciprocal trade agreement under the guise of compliance with WTO law. The Trump administration started the talk about replacing AGOA with reciprocal trade agreement. That the result is the US-Kenya negotiation. China has started, the first free trade agreement, reciprocal trade agreement with an African country signed with China. So there is a significant shift in the external legal regime governing African countries, at least with their major trading partners. So when the CFTA came into force, those expectations that the CFTA will now be an instrument where African countries come together and negotiate didn't really materialize, mainly as you mentioned earlier as well, because, for example, when you take Kenya, the strongest argument, and also said Kenya is making is that if, for example, AGOA expires in 2025, the other EAs are not going to be affected because they are LDCs and they will still continue to benefit from the GSP scheme, whereas Kenya is developing. What this tells you is, even if we talk about continental solidarity and similarity of African countries are at different level of development with different economic and political interests, right? So they want to pursue this interest on their own. But again, that difference that makes it difficult to write provisions that are clear in terms of their message. For example, the EAC, if you look at the protocol on customs union, it doesn't really prevent Kenya to negotiate, even if they say it's a customs union. It doesn't really prohibit member states to go alone. What it says is they have to notify, and member states have to deliberate on it. But it doesn't say what the consequence of decision will be. So there is a gap in the drafting as well. So that gap gives an loophole for countries to pursue individual agreements. So I think it's a combination of different factors that is playing out in the external dimensions of African FTAs.
Okay, thank you very much. So Chena, I'd like to also note your other questions, and you've raised pretty good questions. And another question that he's raised, and unfortunately, Senai is not here to talk about what he raised in his presentation as the involvement of especially Western funds and interest in the African integration process. I know none of you in this panel have addressed that, but is there anybody that would like to talk about, how do we balance, our very strong, aspirations to go at this alone, but we still have a lot of external in terms of funds, in terms of hands, in terms of minds, in our own regional integration process. If this is not something that you want to deal with, I'm happy to move on to the next question. I see that there are no takers. Okay. All right. So I'm going to start from the bottom because, okay, so we have a question from James Kapi, who says sorry, I think the question was broken up into. So this is to Harrison about the Safaricom Ethiopia deal. And he notes that Vodafone UK has at least 85% shares in Safaricom. Okay, that question kind of broke off, James. Maybe if you want to repeat it. Okay, I see another one from you. Okay, let's see this one. Without a schedule of tariff concessions not being finalized, how is implementation or operationalization proceeding? I know this is sort of the governance aspect that Senai was dealing. Is there anyone that would like to deal with this question? Oh, I'm very sorry. Uchena is a she. I beg your pardon, Uchena.
I think,
yes.
Well, if I may
yes.
Well, the start of trading, as they announced it, were commenced in January 1st, 2021, this year, among state parties that have ratified the agreement. Yet there is this problem of sale of concession. How do you know which goods realize what tariff applies to what, and which goods do not actually benefit from tariff exemption is very something that needs to be on the table for transparency, for traders to know that what they're actually engaging in. I think this is where the announcement somehow, well, I would say, member states are really keen to actually. That's why the training of the customs officials actually going on at the moment, to be aware of the fact that what actually applies in terms of tariff, in terms of negotiation of the member states. But the tariff and the rules of origin, and also these are the things these are the issues that are still pending at the moment, where member states actually believe that until they are completed, at least until they are published, made available, trade cannot actually proceed smoothly. So trade officials are border officials and customs officials are receiving training regarding at least what they are going to be facing when these instruments are finally published. But again, I agree with you, Professor Gatti, that until these schedules are actually made completed, trade cannot be said to be going on under the AfCFTA as it stands at the moment.
I think from what I heard from the Secretary General is it seems a very inventive way of operationalizing the CFTA. So what has happened is member states have agreed that trade will continue as it is, but all the trade will be registered for CFTA purposes, and traders will pay taxes, but this is going to be refunded once the schedules of concessions are agreed and the rules of origins are determined. So it's also sort of a back payment for the exporters.
Maybe I can try the question that Prof. Gadi asked me. And I do this with, tremendous trepidation because he's my PhD supervisor.
Go for it, Harrison.
So I think that I settled, for example, with the Safaricom question at just the farm level and said, this is a Kenyan company. Now, of course, if you now go into the shareholding, then now you find a big problem that we all have to contend with when it comes to intra-African investment, especially with companies. Because at the end of the day, the question will be, what really is an African company? I think in goods, we talk about, rules of origin. So we come up with a complicated area that tries to help us with that. And then we know that this product then is a product not of, Malawi, but it's a product of China because of how we have negotiated the rules of origin. I don't know, when it comes to investment, it becomes very difficult to say whether a company is an African company, because in this case, for Safaricom, having such a huge shareholding that is foreign, at the end of the day, at least there's an economic unfairness that occurs because most of the money, the benefit out of this is not being enjoyed in Africa at the end of the day. But as we know with many investments also, if it's able to create in sort of, I can't say enough, but if it can create some semblance of employment and help the economy to grow and in that specific country, then there is something to be said about it. And I'm not defending any firms here. I'm just trying to sort of think around it. Yeah. Thanks.
Okay. And thank you for the point. And I really take the point. And I think also we need to recognize that there is quite a significant amount of intra-Africa investment that is happening within Africa. And I can, obviously name Safaricom, and then the banks, the West African banks have also, expanded into other markets. South African companies like ShopRite and Woolworths and Mr. Price and et cetera, et cetera. So, this conversation it's very significant in Africa. And although we haven't really taken on the bilateral investment treaties that have been signed between the African states, a dispute settlement mechanism that will help companies, I think, will really be important, to grow intra-Africa investment. And this is very, very important. One thing that I noticed in the chat, and I think Gabriel Masso raised this and a couple of others raised this, is that what is the value proposition for the AfCFTA for countries that are at a much lower level of development versus, the bigger, sort of regional anchors like your Kenyas and your Nigerias and your South Africas and your Egypts? Do we think that, I'm sorry, I'll just have interference. Do we believe that countries like maybe Lesotho and Burundi would also stand to benefit as much as, sort of the natural sort of economic hegemons? I'd just like to hear your perceptions, and maybe also address a little bit, Reggie, what you said in your chat without really saying that, how protectionist the bigger economies can tend to be in general.
Well, I think that the argument actually it speaks to the same argument that you had in the WTO. Why would developing country or least developed country join the multilateral trading system where they are developed countries? I think the same argument can be brought into why you have more developed and least developed. That is why you have this variable geometry in the CFTA, for instance, to accommodate these smaller state bodies to actually receive technical assistance. The Secretariat must offer technical assistance to those countries, and then they can implement the agreement at their own pace. And if you have the modalities for the liberalization of goods, that actually give them longer time frame to liberalize goods that they have designed, that are designated as sensitive products or more general products. So basically, this is the mechanism that been put in place to accommodate smaller and more weaker players. And well, in terms of the question that Harrison was actually answering now, there are, I don't know which protocol actually specify the amount of shareholding that needs to be in a company to qualify as a company owned by a national of a member state. I don't know whether it's either the service protocol or the free movement of protocol. There is an instrument that actually tells what amount of shareholding is necessary to have the company or the service providers to be a service provider of a member state. So I think this is.
Yes, Henok, please.
Thanks, Carl. I think we need to recognize that the CFTA or any trade agreement is not going to benefit everyone, right? There are going to be losers and winners. It's all about what mechanisms are installed to really compensate the losers. It's obvious that the bigger economies that are, capable of producing manufacturing goods, for example, are going to benefit from the liberalization of trade goods in the continent. So the Egypt, Nigeria, South Africa are, they stand to benefit a lot than the smaller economies. There are attempts within the CFTA legal framework, for example, to respond to this through the variable geometry, but also through special and differential treatments. So there are attempts, but I'm not sure that is enough to sort of encourage these countries to actively participate. Part of the reason as well why we have this issue in terms of implementation. There is the convention at the continental level to provide integration process. When it comes to implementation, we always face problems here and there, and that partly comes from that kind of lack of mechanism to address those concerns. And I don't think the CFTA has completely responded and addressed this. But sometimes it's also surprising for me, for example, you'd think the major economies would be active in the integration process. They want to drive the process because they stand to benefit. But you see Nigeria, really hesitating to ratify the agreement. So sometimes I think there are a lot of things beyond the economic interests that play a role in the integration process.
Absolutely. I mean, I couldn't agree with you more. I see that we have about a minute and a half left, and I would like to really give you, a 30-second wrap up before we close. And thank you so much for your involvement, and thank you, of course, to our audience for the very, very pertinent and very interesting questions that you've raised. That I think I enjoyed definitely the discussion. So if Harrison, you could lead us with your 10-minute or 10-second or 20-second close, and then we'd go to Reggie and then to Henok, please.
Thank you, Kolo. Mine will just to say that I think the entire panel has shown that we need to move with some sense of cautious optimism with the AfCFTA. I have seen, sometimes there's just too much, excitement around it. And if you know the realities and the pragmatism of trade, investment, and the number of things we are putting on it, I will say that my closing will just be like that, let's move with some sense of cautious optimism.
Go ahead, Reggie, and then Henok right off.
Yes, like I said, the integration of Africa cannot be centered on people, where there is still so much to be done on that particular sphere of integration, whereby you can see that not only there is not enough enthusiasm around the free movement of people, and then you see also that even when it comes to standing to when there is a implementation problem with the instruments, the individuals and companies do not have the right to actually bring claim before any forum that has been put in place to litigate matters. So I think these are some of the reforms that need to be brought into the. Hopefully the protocol on investment will actually try to amend or at least bring some reform in that regard. So. Thank everyone for their participation, and looking forward to our conversations.
Thank you so much, Kolo, for the excellent moderation and for a great discussion. I think I share Harrison's concluding remarks. I think there is a caution needed in the implementation stage of the integration process and the CFTA in particular. I feel personally that there is a lot put on the table. The agenda is consistently expanding, whereas we are not really addressing the issue that's the core issues. For example, we haven't really fully addressed trading goods, but we have really added a few more issues on the table. So I think it's important perhaps to pause and, and then reflect on what has been achieved so far and try to complete those we started before adding new items in the agenda. Thank you.
Thank you. Thank you all so very much. Thank you for the audience for your active participation, and thank you for the august panel for your input. Really, it's really been a stimulating and very interesting session. So without any further ado, I know we've gone a little bit off time. I'd like to close the session, and I hope you all have a very good rest of the day, morning, evening, and I hope to see you all very soon. Take care of yourselves. Bye-bye. Bye. Thank you so much. Bye-bye.